Hello, everyone. Welcome to the ATAR Notes July lecture series, as well as our lecture for Legal Studies Units 3 and 4. My name is Sunny, and I'm really excited to be delivering this lecture for you all today, and I hope that you find it super helpful. So on these slides, you can just see some of the resources that ATAR Notes has to offer, but let's jump straight into the lecture, and I'll start off by introducing myself first. So, as I mentioned, my name is Sunny. I completed my VCE in 2021 with an ATAR of 96.70 and obtained a study score of 47 in legal studies. And I'm currently studying a Bachelor of Paramedicine degree at Monash University. So here is the layout for today, as you can see. So we've kind of split into two blocks. In the first part of the lecture, we're looking at Parliament and the Australian Constitution. And in the second block, we're looking at the Victorian courts and the High Court in lawmaking. So, as you should be able to recognize, we're covering Unit 4, Area of Study 1 today. Basically, all of the study design and all of the key concepts that will be assessed on your stacks and on your exam are going to be covered today. So, you can follow along on the bottom bar as well, where you can see the layout of everything we're covering in the lecture today. Um, and the live chat Q&A is obviously on the page where you're viewing the lecture. So I will be present on that live chat throughout while it's being broadcast. So feel free to ask any questions about the subject at all or about the content that is being covered, as I will be on that live chat answering you guys' questions while you're watching the lecture as well. Amazing. So, first of all, I really just want to remind you of the importance of working with your study design. Um, the content in legal studies can be a little bit overwhelming as well as in your textbook, but you don't need to know everything. So, look at your study design to see what is actually going to be assessed and what those key knowledge dot points are. The key knowledge dot points show you all of the areas you need to be able to answer for questions and will help you to narrow it down. So also, when you're preparing for SACs or for the exam, you should be reading the study design and checking if you can answer and provide detail on every single dot point, as those are the accessible points. And then the key skills dot points obviously provide what type of questions you might get. Um, so let's just go through it together before we actually start looking at the content. So for Parliament and the Australian Constitution, which is our part one, you need to know the roles of the Crown and the Houses of Parliament in lawmaking, and that includes both Victorian and Commonwealth. So there is a lot of overlap between these roles, but you also need to be able to differentiate between the upper house and the lower house. The lawmaking powers of the state and Commonwealth parliaments, including exclusive, concurrent, and residual powers. Obviously, this includes being able to provide some examples of each, not only just a definition. The significance of Section 109 of the Australian Constitution, so we'll be looking at that as well. These will be explain questions, meaning you need to be able to explain Section 109 and what it entails in a little bit more detail, as well as being able to provide an example. One High Court case which has had an impact on state and Commonwealth lawmaking powers. And this impact, what that basically means is due to a high court case, a high court interpretation, where both the state and Commonwealth were parties in that actual case, right? You need to be able to discuss a case where basically explaining did the state or the Commonwealth lawmaking powers expand or reduce. And usually you'll find this pattern at the very end. We'll look at quite a few different cases, more examples than you actually need. And you'll be able to see that usually, due to high court decisions, the Commonwealth's lawmaking powers are expanded and the state powers are reduced. And that's generally what happens with most of these cases where they're both parties. Also, the factors that affect the ability of Parliament to make law. So, with the study design changes as of this year, students actually needed to know five, and now you only need to know these three. So, the bicameral structure of Parliament, bicameral meaning two houses. So, both a lower and an upper house exists both in the Victorian and the Commonwealth parliaments. International pressures. So, consider international events such as terrorism or COVID-19 pandemic. We'll be using COVID as the example for this one. And the representative nature of Parliament. The fact that we have regular elections and members of Parliament must be representative of the people's views. And if they are not, and they do not create laws that the public is satisfied with, obviously there are regular elections being held. So that means that we have the ability, and obviously in a democratic structure, to change the composition of Parliament by voting for other parties. And the means by which the Australian Constitution acts as a check on Parliament in lawmaking, so ensuring that there is no, corruption or abuses of power. The Constitution, the reason it is, such a strong protection for us as members of the public is because nothing in the Constitution can be changed without a successful referendum. So unlike just your usual, laws and acts, Parliament can change any of that as they wish. They just need to initiate and pass a bill which is, a proposed law. But the constitution can only be changed by means of a successful referendum, which, has happened in Australia many, many times. But due to the double majority requirement that you'll also learn about later on in areas of study two, most referendums in Australia are unsuccessful. So these include the role of the High Court in protecting the principle of representative government, so ensuring those re-elections, ensuring that there are two houses, that's all enshrined in the Constitution. The separation of legislative, executive, and judicial powers. So the separation of powers is not to be confused with the division of powers. That's a big thing that I point out to students as, generally on the exam every single year. If a question about the division or separation of powers comes up, there will be still a substantial proportion of students that answer the question completely wrong because they confuse the two umbrella terms. So the division of powers is this one up top where it mentions exclusive, concurrent, and residual. And the separation includes legislative, executive, and judicial powers. We'll talk about this more when we actually get to it. And then the express protection of rights. So there are five express rights for all the people in Australia that are enshrined in the Constitution and they cannot be taken away, such as the right to freedom of religion, the right to not be discriminated against based on your state of residence, so which state you live. And free interstate trade as just some of the examples. You will need to know all five as well as their respective sections. So I know Unit 4 is where it gets really, really different. You're used to, and in year 11, you also studied the civil and criminal justice system. So all of this stuff that comes in at Unit 4 about Parliament and the Constitution and the courts can be quite tricky to navigate for students. They often also find it very tedious and hard to remember all of the sections, understand, some of the difficult language and lots of terms that come up around this area of study. So the key thing to do is, don't try to memorize concepts. Make sure you actually engage with the content and you really understand all of the content. That's really, really key. Explaining things in your own words is, absolutely fine and should be the standard. You don't need to memorize sections of the Constitution. You just need to really engage with this area of study and have a really great understanding, and then you'll actually likely find it easier than Unit 3 if that is the case for in terms of your study methods. So make sure to take note of that, and that's what I recommend for Unit 4. Um, so the key skills basically show what type of questions you might get for this area of study. So you need to be able to define and use legal terminology. That's always the case. So providing definitions, discuss, interpret, and analyze legal principles and information. So this is where you might be presented with fake scenarios and things like that, or articles, and you need to be able to use stimulus material to answer questions and incorporate information from the stimulus material into your responses to get those full marks. Using stimulus material effectively is very important because half of your marks on the exam, so the whole part, second part of the exam, is based on stimulus material and is worth 40 out of your 80 marks. At this stage of the year, you should be really confident in incorporating stimulus material. And that doesn't just mean mentioning some of the facts from, the case and using the names of the people mentioned. No, for your actual discussion or evaluation points, depending on the question, the examples you should be using to, answer those discuss or evaluate questions should be coming directly from the stimulus material. So it cannot be random general points that you're using. Um, or you won't get those marks. You won't get those marks for using the stimulus material. You will also have to be able to explain the lawmaking powers of the state and Commonwealth parliaments using examples. So this refers to your division of powers as exclusive, which belong to the Commonwealth Parliament, residual, which belong to the state parliaments, and concurrent, which are shared across both parliaments. You'll also have to analyze the relationship between Parliament and the courts. So, how do the courts influence Parliament, and how does Parliament influence the courts? Explain the significance of Section 109 of the Australian Constitution. Remembering with your explain questions, that keyword explain means you need to describe in quite a bit of detail and then also be able to provide an example. And discuss the significance of one High Court case, which has had an impact on state and Commonwealth lawmaking powers. So we'll be looking at a lot of these today, so you'll really be able to take your pick, and discuss the ability of Parliament and the courts to make law. Um, Evaluate the means by which the Australian Constitution acts as a check on Parliament and lawmaking, and we said there are three specific dot points under there that you'll need to know. And then, of course, yeah, that use of stimulus material is mentioned here. So if you can really see how clearly the study design lays everything out for you guys, you really should be using it to study and check yourself that you know everything when doing each area of study. So, if you haven't already, make sure you have your study design for legal studies printed out, sitting on your desk, actually annotated, and you use that to study because that's the best way to prepare for the exam. You won't get anything outside of the study design. You can also use these key skills dot points to form your own practice questions because they tell you exactly what kind of questions you might get. All right, let's get started with that part one. And the first concept that obviously we're looking at is the composition of Parliament. So, Parliament consists of the Crown, the lower house, and the upper house. And this includes both the Commonwealth Parliament and state level parliaments as well. And you need to know both of these. So, let's talk about the lower and upper house first. The lower house in the Commonwealth Parliament is referred to as the House of Representatives. Within state parliament, so in Victoria, this is referred to as the Legislative Assembly. The lower house is referred to as the House of Government. Um, this is basically, the party that has the majority of seats in this house, so the party that has the most members of that political party when they get elected, uh, they form government. So this means, if that year during the elections, most members that were elected by the people included Labour Party representatives, Labour becomes the majority party because they have the majority of seats. And the leader of that political party, depending on or if it's state or Commonwealth level, they would become the person sort of in charge, right? The minister. So considering that, like the significance of that, what does that mean? Well, when we initiate a law, which is a bill, right? When it's a proposed law in Parliament, if it's initiated in the lower house, but one party has already the majority of seats there, we only need more than 50% of votes to pass that bill along, to pass that proposed law through the lower house. So if we have a party with the majority of seats, forming government, we will always pass that bill because automatically there's more, all the representatives of that party will vote along their party lines. So if their party introduced that bill, they will all approve it. But another protection that we have in place is that bills, in order to become law, must pass through both houses of parliament and attain more than 50% of votes in both houses. So the next step of what happens is, even that bill that has been approved, it will go to the upper house next, which you need to really know these terms. At Commonwealth Parliament level, this is the Senate, and at state parliament level, this is the Legislative Council. So again, when the bill comes to the upper house, generally with the structure that we've got, the the structure of each house is very, very different. So that offers us that protection because generally, while the bill might pass easily through the lower house where the government party is with the most seats, the composition of the Senate will be different. And that means that, if the bill is, genuinely not great for the public and it's only in that party's interest, but it doesn't really represent the views of, the other people, such as minority groups, it likely will not get approved and it will not become law. So that offers us a protection. So the lower house is referred to as, the house of government, and the upper house is its role is to represent the interests of the states if we're looking at Commonwealth Parliament. And if we're looking at state parliament, its role is to represent the interests of the different regions within the state. So that's how we would try to have it balanced structure and make sure that, there isn't all of this corruption. There's just this one party that calls all the shots, the party with the majority of seats, and they enact any laws that they would like. So this is that protection, is having that bicameral two-house structure. Um, Now, lastly, there's the Queen's representative, also referred to as the Crown. So this is not actually the Crown, that's part of Parliament, but is an actual representative. It's not the royalty in England that's doing this, but it is a delegated representative. Their role is any bill that's been approved by both houses, any proposed law that's been approved by both houses, in order for it to pass, the Crown must grant it something called royal assent. This is the very last step when we're looking at the progression of a bill. So before any law becomes an actual law, it must have that formal step where the Queen's representative basically signs it off. So grants it that royal assent. Now, they do by law have the ability to reject bills and not sign them, so they wouldn't become actual acts. However, this generally never happens. This really is kind of a formal step. It has almost never ever happened where royal assent was not granted to a bill. So the Queen's representative, or the Crown, at Commonwealth Parliament level is the Governor General, and at state parliament level, this is the governor. So don't confuse these terms; they are very similar. Okay, so this is just things that you'll have to remember. Okay, so hopefully I didn't lose you. Obviously, you've got, that broadcast going, and, even after the live lecture is over, you can access that recording for, I believe, a week from the same page. So listen to that explanation again, because I didn't just talk about the composition, but I also talked about the process of a bill and how it progresses through Parliament, and hinted at the main roles of the Crown, Upper House, and Lower House as well. But I think if you look everything just in an isolated way, like if we just looked at the names of each house and then the roles separately, it's too confusing because these concepts need to be explained and viewed together. So, understanding the levels of Parliament must be tricky, but inevitably, if you don't understand them, you will be one of those students in legal studies that complains about Unit 4 being very, very hard and very stressful and struggling to understand anything. So, what I do want to point out is these are the key concepts. So, that includes the composition and roles of Parliament, but it also includes the roles of the High Court and the Australian Constitution with regards to all of this, in order for you to be able to grasp the rest of the concepts. And then when you do Unit 4 Area of Study 2, you would definitely be lost if you don't get these key concepts right. So take it step by step, listen to that explanation again, and do additional research. Have a good read through your textbook as well. So roles of the lower houses. So we said we need to know these roles. They're accessible. So remembering again that at Commonwealth level, this was the House of Representatives, and at Victoria, this is referred to as the Legislative Assembly. So these are all the roles of the lower houses. So form government. How does this happen? Because you actually need to explain when you're giving any roles as part of your response. So we said the party that has been elected the most and holds the most seats in the lower house becomes the government party. And they have automatically then, obviously, if they have the majority of seats, they have more than 50% of that party's members in the entirety of the lower house, so they can just easily pass bills because they will vote along their party lines and they will all approve bills that they are in favor of. Okay. Uh, and they will also initiate debate and vote on bills. So with this role, this overlaps between the lower and upper house. This role is the same in both houses. Both the upper and the lower houses can be the first to initiate the bill. Okay? And it's the same kind of thing, even if a bill is initiated, in the Senate, in the upper house, it needs to be approved by both houses in order to actually become law. However, the whole idea is, we said the lower house is basically the party that is the house that represents the people's interest and has the government party present. So that means most bills are actually initiated in the lower house. Still, sometimes bills are first initiated in the Senate. Okay. They also control government spending. So any money bills, any bills related to increasing or changing funding for any sector in Australia, or if it's state level within Victoria. This is important because this is a key differentiating role. The Senate actually cannot initiate money bills. This is exclusively a role of the lower house. And it makes sense because the lower house forms government, which is also exclusive to the lower house. Okay? They also act as a house of review. Again, because bills can be initiated in the upper house as well, meaning that the second house that they would go to, if that is successful, is the lower house. So both houses technically have a role as acting as a house of review, both the upper house and the lower house. It just depends on, who's getting the bill second. And if the bill is coming to the lower house after being introduced in the upper house first, then the lower house is acting as a house of review. They have a role in scrutinizing government. This applies both to lower and upper houses. So, of course, other parties that are not the government party will be critiquing policies that the government party is trying to introduce, talking about how they're inadequate or not representative of the people's views, or requesting for some amendments, changes to be made in return for their approval on those bills to allow them to pass through, basically. They can examine bills and issues in committees. So these include the specifically referred to parliamentary committees. So with regards to any bill, a really thorough investigation can be initiated by Parliament into the idea or the concept basically behind a law that they want to propose. These are very expensive and quite time consuming things, but sometimes when the law is really inadequate in an area and it's not very clear how to fix it or what the consequences could be, a parliamentary committee may be initiated to help better understand what could be done and what could be the best like laws. And we said representative government is formed in the lower house. So this refers to the fact that there will be regular re-elections every few years, and if the people's views are not being represented by that government party, the government party will likely change because people will be unsatisfied and they will vote for a different party. Now for the roles of the upper houses. So what I'm kind of trying to point you guys towards is it's much easier to do well if you just categorize and remember which roles of the lower and upper house overlap and which roles are distinct and different between each house. So that's how I recommend studying for this. So this is the Senate at Commonwealth level, and this is the Legislative Council at Victorian level. So the roles of the upper houses, unlike the role of the lower house, where the role is to form representative government, meaning that we need to represent the views of the people in Australia, the upper house is representing the interests of the states at Commonwealth region, at Commonwealth level, or representing the interests of the regions of Victoria at Victorian level. So this is different. Um, So, for instance, just to help you understand this, the compositions are really different. The lower house is, just chosen by the people, depending on, who's getting the most votes, they will become members of the lower house. Okay. Whereas in the upper houses, so let's look at Victorian level, for instance, there is a set number of representatives that will form the upper house from each region that Victoria is divided into. So there is geographical representation when we're looking at the upper house based on distinct geographical areas. That's how we represent the interest of regions of Victoria, not necessarily the people. Okay, so you can see that election process is really different. A certain number of members from each region are elected into the upper house, whereas with the lower house, it all just depends on people's votes and isn't necessarily decided based on region and geographical area. So it's the same thing when we look at state level. There's a certain number of members of the upper house from each state that are elected, and quite less from each territory. So territories contribute way less representatives to the upper house. Not sure if that is fair when we're talking about, accurate representation of the states, but it is the way that it is set out in the Constitution. So unfortunately, that cannot be changed. Um, Now, they also initiate debate and vote on bills if they're, the house that's the bill is being initiated in. However, remember this important difference: the Senate or the upper house, they cannot initiate any money bills relating to government spending and allocation of spending. They also act as a house of review. If the bill is coming to the upper house second after being introduced in the lower house first, they also scrutinize government, so examine flaws in a proposed law, and scrutinize, the motivations, I guess, of the government party. And they can also examine bills or issues in committees and parliamentary committees. So hopefully that's all confident. I feel like I've given quite a good explanation for each role that we've looked at. So now looking at the roles of the crown. So in Australia, we have what's called a constitutional monarchy, meaning that we have a monarch, which is the crown and is the head of state. Obviously, the monarch or the crown refers to the royals in England. Um, and constitutional refers to the fact that we have a constitution protecting us, and all of our rights and key fundamental laws are outlined and can only be changed via a successful referendum. So, meaning that this prevents any sort of corruption, as Parliament cannot do as they please. They are actually constrained by anything that's outlined in the Constitution, and they cannot change any of those principles. Um, so the Crown is represented at Parliament level by a governor, if we're looking at Victorian level, and at Commonwealth level by the Governor General. So this is just a representative of the Crown that signs off and grants that royal assent, approval for a bill to pass at the very end when it's been accepted by both houses. So the governor doesn't really have any powers like the Crown. They're just simply a representative of the Crown. This is kind of a formal step, really. Now, these are the roles of the Crown. So they grant royal assent, we said, so they can approve and sign bills, which will make them into laws or legislation. So it is that necessary step for a bill to pass and actually become a real law. We said they also have the ability to withhold royal assent. So they can actually refuse to approve a bill, but this very rarely happens. It's almost never happened. They also appoint an executive council and also appoint federal judges. So this means that they basically, this is also formal. Okay, so we know whoever was the party that had the majority of seats in the lower house becomes the government party, but they appoint them. Okay, so that's just more like a formal step. And they also appoint federal judges, so Commonwealth level judges. So this is obviously referring to the High Court of Australia, not a state level court. Why does the Crown do this? Well, technically, this helps to ensure that there's no overlap. If the members of Parliament or the government party were the ones to appoint federal level judges, then they could just choose people they like, and there would be, corruption. So instead, we have the Crown appointing the government party and appointing the federal judges. Um, and, technically, the Crown is part of Parliament, but there's no real overlap because they don't actually sit in Parliament and everything like that. They just have that role of granting or withholding that royal assent. Okay. And they can also dissolve Parliament. So in the instance that there is, corruption that's been discovered or something happening that should not be happening in Parliament, obviously this is really rare. They could dissolve the whole Parliament, meaning that elections would be held again. Early elections would occur to re-elect the entire Parliament all over again because something happened. Okay, so our next concept is the division of powers, and I feel like this concept helps to explain all of the roles of the lower and upper house and the Crown as well. Now, first of all, being able to define it. So, lawmaking powers are the powers given to Parliament to create certain types of laws. So, we have the division of powers enshrined in the Constitution so that we are able to decide which Parliament gets what powers. Imagine if there was confusion about this. Imagine if both Commonwealth and state level parliaments could make any laws as they please in any area. What we would have then is we would have inconsistency between those laws, and it would be unclear to understand which is, superior. Do I abide by the laws regarding this concept present in my state, or is it the laws of at Commonwealth level, at Australian level that I have to follow? So this would cause a lot of issues in the courts as well, because the courts, if there's conflicting laws present, how could they possibly decide during a dispute who is in the right or who is in the wrong? And if a person has or has not broken a law, if they are different. Okay, so this is why we must have the division of powers to delegate all the areas in which both the states and the Commonwealth can legislate in. So these include exclusive, concurrent, and residual powers. So we need to be able to provide a definition for each and give examples. Okay, so now exclusive powers are the lawmaking powers that are held only by the Commonwealth Parliament. So in these areas, only the Commonwealth can legislate and the states cannot legislate in these areas. So the examples are really easy to understand and come up with. if you have a look at these examples, they're clearly things that the states shouldn't be able to decide. Um, so these include things like defense, military, the currency within Australia, border protection, import and export outside and into Australia with other countries, um, and signing, treaties and things and declarations with other countries, things like that. Okay, so these really are only the areas that relate to things like international trade and currency and domestic issues. So most powers and areas in which we legislate in are actually residual. They're not exclusive. Residual are the powers that belong to the states and the matters on which the states can legislate in. There are actually, what I'm saying is, there are actually not that many exclusive powers, just because the whole nature of the concept, the Commonwealth level law applies to areas that refer to international trade relations, um, and there's not that many. Okay, so we said exclusive powers are held by the Commonwealth, and we're able to define that and provide a few examples. Now, concurrent powers, it's literally in the name concurrent, so clashing or shared. Okay, so these are the lawmaking powers that are held by both the states and Commonwealth parliaments. And you might be thinking, well, how does that work? How can we have, um, wouldn't we have those overlapping laws or different laws if that is the case? And this is where Section 109 of the Constitution is coming into play, which explains exactly what will happen if both a state parliament and a Commonwealth parliament make law in the same area and the laws contradict. So we'll look at that in a second. First of all, what are some examples of concurrent powers? So things like trade, taxation, and laws around marriage and divorce. So, for instance, with the taxation example, if we have a think about this, how's that concurrent? So, if we look at Commonwealth Parliament level, that would include the tax you get on your income and your tax return. That is a Commonwealth level law that applies to everyone. Everyone gets taxed the same all over the country, no matter which state they live in. Okay. However, if you look at state level taxation laws, there are many examples here too. So, for instance, when someone owns a house or land, they have to pay tax or money to their local council. Okay, so there are state level and Commonwealth level laws regarding taxation. So that helps to give you an example of some concurrent powers. So let's see Section 109. Remember, this is really accessible, so you need to be able to explain this in quite a bit of detail. Section 109 explains what occurs if under concurrent powers, a state law and a Commonwealth law contradict each other. So the actual section of the Constitution explains exactly what's going to happen. When a law of a state is inconsistent with a law of the Commonwealth, so they are clashing, the latter shall prevail, and the former shall, to the extent of the inconsistency, be invalid. So this is saying that when a law of a state is inconsistent with the law of the Commonwealth law will continue to operate. Because the Commonwealth law, it makes perfect sense, it should be superior over a state level law. And the state law is abolished or it's gone, but only to the extent of the inconsistency. So only the part of the state law that contradicts with the Commonwealth law will be abolished. And the rest of it will operate as usual. We only care about there being no contradictions. If there is a contradiction, the Commonwealth is superior and their law will prevail. So, very important when you're answering these questions and what will get you and where you will lose marks is if you forget that state legislation only becomes invalid to the extent of the inconsistency. So, the part that is contradicting only. Okay? So, that's very, very important. You're welcome to, for the sake of your responses, actually memorize the section and what it says. I definitely used to just have it memorized because it's quite an easy section. But you're absolutely free to explain it in your own words. Just don't miss to the extent of the inconsistency. Very important. So you can really see that section 109 is yet another law or section of the Constitution that helps to expand Commonwealth law and Commonwealth's lawmaking powers at the cost of the state's powers. Um, which, when we look at the High Court cases that you need to know, we said you must know one High Court case in relation to both state and Commonwealth Parliament. You'll see that this is always really the case. Like all the High Court decisions tend to result in an expansion of Commonwealth law and a reduction in state lawmaking powers. Okay, so we looked at exclusive powers, which belong exclusively to the Commonwealth, concurrent powers, which are powers that are held both by state and Commonwealth parliaments, and now we have residual powers left. And I mentioned that these are the majority of lawmaking areas are actually residual. So most lawmaking power is held by state parliament. Not by Commonwealth, by state parliament. Okay, so residual powers. Again, it's really easy to remember because residual means everything that's left over. So these are lawmaking powers held only by the state parliaments, and essentially it is any area that is not mentioned in the Commonwealth Constitution. By default, that becomes a state parliament power. So anything that's not mentioned in the Constitution and given to Commonwealth Parliament automatically is a residual power and is a state power. So this turns out to be the majority of lawmaking powers, exactly what I said. Most lawmaking powers are residual and belong to the states. And why that is the case, because when the Constitution was initially established and written, the purpose was not to take away power from the states, but allow them to retain it. So obviously, Australia coming under one country, all of the states and areas had concerns that they will lose all of their freedom, and there will be a single parliament and everything will change. So the Constitution aimed to bring them together and leave them most of their powers and allow them to retain it to help encourage them to establish a single country and a single Commonwealth Parliament. um, and that was the whole purpose of that Constitution. So what are some examples of residual powers? So things like public transport. The public transport system, such as the train system, is different in every single state. Um, Criminal law as well. There are different laws in each state with regards to crimes in the criminal justice system and penalties and sanctions, different fine amounts for different offenses, as well as different sanctions for each serious offense, as well as education. So every state also has a different education system. So the ATAR, all students get an ATAR across the country, but all the systems are different under which you study and the layout of subjects depending on the state that you are in. Okay. So we've looked at all the three powers, and now we'll look at how the Constitution acts as a check on Parliament's lawmaking powers. So remembering back to when we looked at the study design, and I was explaining that this refers to how the Constitution is able to limit Parliament from corruption and being able to make laws as they please without any restraints. So these three ways are the separation of powers, not to be confused with the division of powers, which is what we just looked at, the express protection of rights, and the role of the High Court in interpreting the Constitution. So let's look at each one. So the separation of powers is a principle established by the Commonwealth Constitution that ensures the three main functions performed by Australian Parliament are kept separate. So this really helps minimize any corruption. So, what are these three divisions? They're the executive power, the legislative power, and judicial power. Now, to explain each one, executive power is the power to administer the laws and manage the business of government. So these are all of our ministers that have like certain roles, such as the treasurer that is in in charge of, funds, and minister of education that is in charge of the education system. These are all examples of executives. Now, legislative power is the power to actually make laws. These are all of our members of parliament that are both in the lower house and in the upper house. So, what can we see here immediately? Well, the separation of powers is not actually separated because executives are also members of parliament. All of these ministers, like the treasurer, minister of education, etc., they're also members of parliament. In fact, the government party, the representative of the government party, or the leaders, such as, the prime minister, elects all of the ministers to become executives from members of their party that are in parliament. So they have all of this power. Executives and legislatives um, have technically both powers, and there's a big overlap between executive and legislative power. However, judicial power is kept relatively completely separate, which is really important that our judges are not biased and have no affiliation to any members of parliament or any executives slash ministers. So, judicial power is defined as the power to enforce the law and settle disputes. So, don't confuse the two. Again, very important. Remember, the division of powers was when we were referring to the division into exclusive, residual, and concurrent. And the separation is referring to keeping the key powers involved in lawmaking separate. So this is exactly how I would remember it, and I think it's really easy to remember if you view it this way. Division, how powers are divided between Commonwealth and state level parliaments, hence division into those exclusive, residual, and concurrent. Separation, how we prevent corruption by separating all of the key lawmakers and ensuring that there's no overlap of roles. So a member of parliament can be a judge and so on. Okay, so you need to know the strengths and weaknesses around the separation of powers. And for all of those three concepts that come under how the Constitution acts as a check of parliament, you need to know strengths and weaknesses. These will be evaluate questions. So, some of the strengths are that the separation of powers is entrenched in the Constitution. It's literally in the Constitution, so this is a protection that cannot be abolished without a successful referendum, and therefore protects us and makes sure that Parliament cannot take this away and we remain protected. Um, and it allows for executive to be scrutinized by legislature. So this means that the representatives of executive powers, the ministers, they can be scrutinized or criticized or changed by the members of parliament, which are representatives of our legislative powers. And another strength is that the judiciary powers are judges. They're independent from both parliament and government, which is very, very important. Now, limitations or weaknesses. We said the legislative and executive overlap. They're both members of parliament. This obviously decreases the check of the separation of powers and means that some corruption can be present. Additionally, even though the judiciary powers are relatively separate, judges are still appointed by the executive. Remember, one of the roles of the crown that we looked at, so our governor general or a governor, depending which level, state or commonwealth, is to appoint federal judges to the high court. However, the crown is actually, uh, holds both legislative and executive powers because of its roles. So this means that there is an overlap between judiciary and legislative powers because the crown has this role to appoint judges. Additionally, the Constitution only provides for the separation of powers at a federal level. Any principle or anything that's enshrined in the Constitution technically applies to Commonwealth Parliament, not state parliament. This means that a state level parliament could fail to abide by the separation of powers and do whatever they wanted. For instance, have members of parliament become judges. They could technically do that, but they don't. There's just a risk that they could do so because they're not restrained by the Constitution. So the next concept that we need to know coming under this is express rights. That's also another constitutional protection against Parliament's potential abuses of power. So express rights are also known as explicit rights. They're all the rights for people of Australia that are specifically listed, or better terms that you could use are entrenched or enumerated in the Constitution. So just making sure you're using accurate and strong terminology. Don't use listed. Preferably, you would be using the word entrenched or enshrined in the Constitution. They're specifically mentioned in the Constitution. And similarly, that means they cannot be abolished without a referendum. So, meaning we have all of these protections for us. However, we only have 5. So these include the right to freedom of religion, which includes section 116. This means that because you need to be able to discuss all of them and know all of them in their sections, guys. The right to freedom of religion is technically only state level as well, so that's a bit of a limitation. However, it does include the idea that Commonwealth Parliament cannot declare one religion as the religion of the country, and people's religious practices and beliefs cannot be restricted or punished or anything like that. And everyone has a right to practice whatever religion they have freely. The next one is the right to free interstate trade and commerce under Section 92. Again, a flaw with this is that it is Commonwealth level, a law. However, this basically just ensures that trade between all of the states can happen for free. Okay, so you don't have to pay any money or tax if you are a business that's delivering products across state lines. There's also the right to receive just terms when property is acquired by the Commonwealth, which comes under Section 51, subsection 31. This means, again, a flaw of this is that this express right is only federal level. So states could do anything they want, technically. This one is quite limited because this basically gives Commonwealth the right to attain your property if they need it. So if they need to build something for whatever reason, they could, take your house from you or your business. However, it means that you must receive just terms. Now, this is obviously very broad. So what these just terms are and whether they're adequate and whether they're really just is unfortunately up to Commonwealth to decide. So, that might just be in the form of give you a different property or just give you financial compensation or give you enough time to leave and clear out. But unfortunately, it's broad, so it definitely, rather than protecting people, exactly it protects the Commonwealth more and gives them the right to take your property. There's also the right to trial by jury for indictable Commonwealth level offences under Section 80. You should already be highly familiar with this one from the criminal justice system. An indictable serious offence will have a jury trial at Commonwealth level. So yes, we get a jury for indictable offences in Victoria as well, but that's only because of state level legislation. So technically, states can legislate this right away and people may not get juries if it's technically, again, only federal level protection. And then the last express right is the right to not be discriminated against on the basis of the state where you reside, which is under Section 117. Again, only Commonwealth level. What this refers to is the idea that you should be able to move from one state or to another and you should not experience any difference in treatment or any discrimination. So you should have the same opportunities to apply for jobs, apply for accommodation, have to deal with the same salaries and the same costs as any other person living in that state to which you're moving to or traveling to. Cool. So what are the strengths and limitations we need to be able to discuss? So it's obviously a strength that they're entrenched in the Constitution and they cannot be abolished without a referendum. Additionally, if a person believes that a law has been imposed that it infringes or breaches upon any of their express rights, they can initiate a case to the High Court. So, for instance, if a law was introduced that limits my right to freedom of religion, whatever the religion I practice is, then I can initiate a case against the Commonwealth via the High Court to try to get that law declared invalid. So that's another strength. The High Court can act very quickly and declare any law that breaches an express right ultra vires. You need to know this term. And this term means beyond the powers of Parliament. So a law that is actually illegal for Parliament to create because it breaches something in the Constitution, ultra vires. There are some limitations with initiating cases through the High Court, though. So, one is that you must have standing. So, if an express right has been breached, you must have been directly affected by that breach. If I was just an interest group or an activist that is thinking, oh, this law that Parliament introduced is horrible, it's affecting people's right to practice their religion, but it doesn't affect me directly, then I actually have no right, I have no standing because I'm not directly affected by that matter, and I cannot pursue this in the High Court. So someone else would have to come along that does have standing, has the money and the time to initiate a case in the High Court. Otherwise, a law that is harmful and contradicts the Constitution, it will continue to operate until a suitable case and a person with standing comes along to the High Court with a claim. So this is mentioning some of those other limitations. If a person's rights have been infringed, initiating a High Court case is going to be very costly and time consuming. Additionally, the requirement for standing is also a necessity, another limitation that I just mentioned and explained. Also, the rights that are protected are limited in scope. So the idea that we only have 5 express rights, they're all very specific and quite narrow too. They don't ensure much. And these are the only 5 that are protected by the Constitution. What is another limitation that we can think of? We said that most of the express rights only operate at federal level, at Commonwealth level, meaning the states can breach them and legislate them away at state level. And lastly, obviously the fact that if laws are introduced by Parliament that breach express rights, they can't automatically be declared invalid. The fact that someone with standing and with a relevant case actually has to go to the High Court and initiate a case against Commonwealth Parliament is the only way. So the last constitutional protection that we need to know about is the role of the High Court. And now this will make a lot more sense since we were just discussing what the High Court does with regards to our express rights. So Section 76 of the Constitution gives the Commonwealth Parliament the power to provide the High Court with jurisdiction to hear disputes involving the Constitution specifically. This refers to the notion that the High Court cannot change the wording of the Constitution, just like Parliament cannot, but they can give words meaning through interpretation. So they can interpret what the Constitution actually meant and what were the intentions of the original Constitution. So we can see that section there. Additional original jurisdiction for the Commonwealth. The Parliament may make laws conferring original jurisdiction on the High Court in any matter arising under this Constitution or involving its interpretation. This means that the High Court isn't like every other court that has that role in statutory interpretation, where we just interpret acts or statutes, so statutory law, to decide what was meant by that legislation to help decide disputes. But the High Court has additional roles, and when it comes to interpretation, not of statutes, but actually the Constitution to help resolve disputes. So this means the High Court has jurisdiction to hear disputes between different states and disputes between a person and Commonwealth Parliament or a person and a state level parliament, and disputes between Commonwealth Parliament and a state parliament as well. So you need to know some of these original jurisdiction of the High Court, some of these examples, so you should memorize some of them. We can see some additional ones arising under any laws made by the Parliament. So this includes Section 109. It includes concurrent powers as well, and any disputes like that as well may be heard by the High Court. And there are some other examples here. You'll have more in your textbook though. So just remember a few of them. Okay, so what are the strengths and weaknesses of the role of the High Court? So some of these we discussed. Judges are independent and can make decisions based upon legal principles rather than political pressures. So we said that this is ensured due to the separation of powers, that judges will have no corruption because they actually have no ties to executives or legislators or any members of parliament. So we're most likely to have fair constitutional interpretations that will be for the sake of actually what was intended by the Constitution and what was intended for the people, and not out of some kind of self-interest. The existence of the High Court also allows laws to be overturned if they are found to be unconstitutional. So this is that power of the High Court to declare laws ultra vires or beyond the scope of the powers of Parliament, therefore declaring them unlawful and ultimately abolishing them. Also, the High Court acts as an independent check on abuses of power. Now, the limitations of the role of the High Court, they can only rule on the facts of cases brought before them. So this means that if people cannot afford the costs associated, or don't have time, or don't have standing, are not directly affected by an unconstitutional law, a dispute cannot come to the High Court, and unlawful laws will continue to operate until that dispute does come. Decision may also depend on the composition of the High Court justices, because in the High Court, there are multiple justices actually making the verdict and the decision rather than just one single judge or person. And the High Court can only interpret the Constitution and determine whether Parliament have abused their power, but they cannot change the wording in the Constitution or make it any clearer or adjust it or anything like that. Okay, great. So unfortunately, more factors. We looked at factors in the Constitution that limit Parliament in lawmaking. Now we'll look at the factors that affect Parliament in actually their ability to make law. So the bicameral structure of Commonwealth Parliament, international pressures, and the representative nature of Parliament are the three that we need to know. So the bicameral structure, we said bicameral, bi is two, so bi meaning two houses, okay? So to define this concept, this refers to a structure of Parliament that consists of two houses of Parliament, the lower house and the upper house. So we said that this is technically enshrined in the Constitution only at federal level. This means that there is one state, Queensland, that does not follow the bicameral structure and just has one house. But all of our other state and Commonwealth parliaments do abide by the bicameral structure. So it is actually really easy to remember because under Section 1, the very first section of the Australian Constitution, it is outlined that there must be two houses within Commonwealth Parliament. we can see that section here. Legislative power. The legislative power of the Commonwealth shall be vested in a federal parliament, which shall consist of the Queen, a Senate, and a House of Representatives, and which is hereinafter called the Parliament of the Commonwealth. Again, so that means immediately we know the first strength, because it's in the Constitution, this right cannot be taken away unless by a successful referendum. Okay, so that's our first strength. Additionally, this ensures that each bill that is passed is scrutinized, so critiqued and debated by two houses. And this means that government cannot just pass through bills that they want, laws that they want, without the approval of the upper house as well, which we said the composition is different. They actually represent the interests of the states. So because there is a different composition, that bill will still only truly come to pass if it is a good bill and it is appealing to other parties as well, due to that different structure. Another strength is that it allows us to identify errors and omissions in bills. So because it needs to go through two houses, other representatives of other parties generally may do something like they might say to the party that initiated the bill, which is the government, they might say that they will only give their approval or yes vote to that bill in return for some kind of amendments or changes to that bill. That might be because there is some kind of error or omission, something missing from that proposed law, or it might be because they want the law to represent their interests a little bit as well. That's why they would like it to be changed. So obviously, still, if this is done, it just helps to ensure that the bills, the laws that are initiated, are really strong, really foolproof. They're going to be effective, likely, and there's nothing missing or errors within those laws. Now, interestingly, though, with amendments, or even if a bill, fails to pass, so if it gets more than 50% of no votes, it can be initiated a second time, but it will have to go through the same process all over again, which is really time consuming. It will have to go through both houses all over again, and all of the members of parliament will have to vote on it. So it is a time consuming process. And that includes if, any amendment or change is made to that bill before it's reached the final stage. Now, the limitations of the bicameral structure. So obviously the structure is not entrenched for Victorian or other state parliaments. We said Queensland does not follow the bicameral structure, for example, and they just have a single house. Another problem is that the lower house is controlled by government, so the majority of seats are held by one party, and therefore laws will generally only be passed through the lower house if they are initiated by the government party or they're supported by the government party. So this is really problematic because that basically means any laws that are not those initiated by the government or not approved by the government, so initiated by another party, but they're still beneficial laws, they likely won't get approved through the lower house, and will fail because we said bills need to pass through both houses. Another limitation is if we have a rubber stamp Senate. So this refers to the structure. We said generally the Senate or the upper house has a different composition from the lower house. But it may occur where the government party in the lower house with the majority of seats has the majority of seats in the Senate or the upper house as well. And this is the circumstances under which the upper house is referred to as a rubber stamp. That name is really telling. So that means just think about the composition. If both houses, the majority of seats are held by the same party, that means they can pass any laws they would like. And any law that they initiate, the government party will pass through unavoidably because of the composition, because of them having the majority of seats. So that can lead to obviously corruption and making laws that are not representative of any other groups in society or even harmful to other groups in society. Okay, and the next one we have to look at is the representative nature of Parliament. So the representative nature of parliament refers to a government that effectively represents the views and values of the majority of the people. So we said that's the role of parliament, and that is ensured by hosting regular re-elections. So we can decide if parliament is representing us accurately in our views or not. So in order to be voted for by the public in the future, the government must ensure that they act to represent the people's views. So the two ways you need to know in which we ensure that parliament is representative, one is regular elections being held. This allows people to elect representatives that they want to make decisions for them in parliament, as we talked about. And the other one is following majority views. So members of parliament that are elected, the ones that become the government party, the party in charge and with the most power, they need to make sure they're following the wishes of the majority of the citizens of Australia. Otherwise, they will not be re-elected again at the next election. So because of this, it can be argued that the need for parliament to adequately represent the people that they were elected by can decrease their ability to create effective law. If you think about that, well, why is that so? We cannot really make laws that are beneficial for the minority groups in society and harmful or in some way affect the majority of people, the citizens of Australia. Because if we get the support of minority groups, we will lose the support of the general public if those laws, are harmful in some way to the majority. So there is no real interest in for government to create laws beneficial to minorities, unfortunately. Additionally, some laws might be really, really needed, but controversial. So, a great example of a law that was controversial at the time, but thankfully did end up being passed in Australia, was laws permitting same sex marriage in 2017. However, that was talked about for a very, very long time by the time it actually happened for many, 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 many years. And the reason it only finally came to pass is because it lost a lot of the surrounding controversy, and the LGBTQI community in Australia had much more support and less prejudice. Okay? So this means that's a great example of a law that was necessary for the happiness of the people, but was controversial, so it didn't happen for a very long time. So Parliament, due to that representative nature, will likely not legislate with regards to minority groups and in enhancing their rights, and will likely not legislate with regards to any controversial laws. So these are the weaknesses when it comes to the representative nature of Parliament. So you can see them listed here. There might be a sense of reluctancy in introducing laws due to vocal opposition, so controversial areas. Members of parliament may support laws that are just popular amongst the majority, as opposed to controversial ones that may be necessary, just so that they can get re-elected. They don't want to initiate or talk about controversial laws if it means they will lose voter support, and they won't be re-elected again in the next term. It can also be difficult to assess the actual views of the majority on controversial issues. So maybe those laws aren't actually that controversial, but Parliament can't really tell because there will be a mix of opinions on social media and articles and the news and things like that. And it might be difficult for Parliament to predict the future and create laws based on the future needs of the community. So laws very easily become outdated and continue to be outdated as Parliament doesn't catch on that they need to be updated for a long time. Now, the strengths of the representative nature of Parliament, obviously, that laws have to be made to be consistent with the views and values of the people. Otherwise, they risk not being elected again. The fact that due to regular elections, voters have the freedom to vote out people that aren't serving them well and vote new members of parliament in, or a different party to become the leading government party. And the fact that we have compulsory voting, so everyone actually has to vote, and you will be fined if you do not vote. And this ensures the majority's voice is being heard and everyone has to vote. Okay, now the last one under this dot point, which is international pressures. And this refers very obviously to the pressures put on all the different parties involved in parliament and politicians by either international obligations or partners. Okay, so this includes, I've got it listed right there, international obligations such as treaties and declarations. So things that Australia is a signatory to and commitments that they have made with other countries. So, maybe some easy ones you can think of, things like UNESCO heritage sites that have to be protected across the world, and then also treaties that say things like human rights and things like that. They're major also international partners, so this includes the countries that Australia does import and export with, and they have to keep a good relationship with, is also an international pressure on their lawmaking. And then also international conflicts. So we said war, terrorism, global spread of disease such as COVID are just some examples of these international conflicts. So looking at the first one, obligations and treaties. So the Australian government could be under significant pressure if they aren't upholding the basic principles of obligations and treaties they have signed to. So interestingly, a treaty, which we said is a agreement between different countries and multiple countries, and we can see some examples of them here. They're actually binding, legally binding under international law. So if a country signs to a treaty and they don't abide by the conditions set out, they might actually suffer some consequences as a result, such as restrictions to trade, international trade, and travel. So obviously, we don't want that to happen. This means this is exactly how this becomes a limitation on Parliament's lawmaking, because if they commit to a treaty, then they must actually make sure that they create new laws or change laws to be in order to be in line with the requirements set out under that treaty and the goal that it's trying to achieve. So some examples of treaties that Australia signed to includes the International Covenant on Civil and Political Rights, um, elimination of all forms of racial discrimination, discrimination against women, Convention of the Rights of the Child, and Convention on the Rights of Persons with Disabilities. These are just the human rights ones, so feel free to, because you need to be able to provide an example, of course, if you discuss treaties as international pressures when you're answering a question. So feel free to have a read in your textbook or look up more other types of different treaties Australia signed to. There are very many. We also have major international partners as a form of international pressure. So the government could be under pressure from major international trading partners or defense allies. So all the countries we do import or export with, or countries we have an alliance with if worse comes to worse and some kind of war or international conflict erupts. So Australia has to consider their partnership with others, especially in regards to economics, trade, and defense when developing foreign policy. So just another thing we have to consider and limits lawmaking. For instance, if we impose some kind of travel restriction to another country or some kind of import or export restriction on them, they could get mad and impose some restrictions on us as well. So you can see there on the image, Australia's top 5 export and import partners. So for instance, we really have to consider China. And if you remember, a long time ago when COVID started, Australia was accusing China of creating and releasing the COVID virus. And then as a result, it was all over the news for a while that they imposed restrictions on our import and export as a result of saying that. So that's a great example. And then lastly, international conflicts. So we said changing international conditions and global events can place pressure on governments to make and reform law. COVID-19 being a great example, because so many different laws were constantly being made and changed in order to try to control COVID-19. And this is an international pressure as well, because by limiting the spread within the country and the effects within the country, we also make sure that the international impact of COVID-19 is not as severe. If there are less people infected within the country and sick within the country, then they cannot, you know, infect more people worldwide and across all the different countries as well. So this is why we had contact tracing, isolation, restrictions on movement and travel, uh, personal protection and masks, etc. Laws regarding all of those things. Okay. So lastly, just a couple of sections of the Constitution for you. Now we're going to be looking at the High Court cases relating to state and Commonwealth lawmaking powers. So remember, you just need to know one example, but out of interest, we'll look at a few more. So I've just got section 7 and 24 here because it relates to the next case that we're going to look at. So section 7 outlines the matters related to the Senate in the Constitution. So the existence of the Senate, what the composition has to be, and how they will be chosen. So we can see directly chosen by the people of the state, voting until the Parliament otherwise provides as one electorate. Section 24, on the other hand, sets out the composition and matters related to the House of Representatives, our lower house. Now, our first case is the Roche case, and it's with regards to section 7 and 24 of the Constitution, which we just looked at. So in this case, Vicky Lee Roche was a prisoner serving a 6-year term of imprisonment. But in 2006, Commonwealth Parliament had passed an act that banned all sentenced prisoners from voting in elections, basically taking away these citizens' right to vote if they were charged successfully and found guilty of any criminal offense. So Roche was quite an advocate for political rights and being able to vote, and was really upset by the fact that they couldn't vote anymore. Previously, there was a 2004 act that only banned prisoners serving sentences of longer than 3 years from voting. But the 2006 act extended this ban to anyone at all that was in prison. Roche obviously had standing because Roche was directly affected by this law and took this matter to the High Court. So, the High Court actually found that the 2006 Act was inconsistent with the Constitution. It contradicted sections 27 and 24 that describe Senate and the House of Representatives, because it clearly states in those sections that Parliament must be directly chosen by the people. So to take away people's right to vote and elect members of Parliament is unfair and is unconstitutional. So we can see that constitutional interpretation occurred in this case. So their decision was to abolish the 2006 Act and declare it ultra vires beyond the scope of the powers of Parliament. However, they said that the 2004 legislation banning prisoners from voting if they were serving longer than 3 years could remain for operation, because prisoners serving more than 3 years have committed more serious crimes and thus should not be a part of voting in elections. So Roche obviously was able to achieve a great thing and empower other prisoners, but Roche was still unable to vote because Roche was serving a 6-year imprisonment term. So in this case, with regards to what happened, obviously, due to the High Court's constitutional interpretation, the powers of the Commonwealth Parliament were actually reduced, and it was clearly decided and shown through this decision that Commonwealth Parliament can't just legislate as they please with regards to taking away people's powers to vote. Okay, our next case is the Brislin case. So part of Section 51 of the Constitution gave Commonwealth power to legislate with regards to postal, telegraphic, telephonic, and other like services. So basically technology. And this was a constitutional Um, this is a section of the Constitution, so this means that this makes this an exclusive power for the Commonwealth, okay? Belonging to the Commonwealth only. Now, what happened was a Telegraphy Act was published by the Commonwealth Parliament that said all owners of radios had to have a license. However, Brislin had a wireless receiving set for a week without a license and was charged with a criminal offense. And of course, because Brislin had standing, challenged the validity of this act. Basically, Brislin's argument was that postal, telegraphic, telephonic, and other like services does not include radios. Now, the High Court had to interpret the Constitution again in order to decide this. And they decided that other like services would include broadcasting to wireless sets and radios. Therefore, this law was not unconstitutional. It's just that future technology could not be predicted when this section was created. And this is why this broad other like services, this term, was included to refer to any other types of technology. So, by adding broadcasting to wireless sets to the meaning of the legislation, the Commonwealth's parliament powers was extended, and it shifted lawmaking powers away from the states to the Commonwealth, suggesting that legislating with regards to radios and broadcasting sets is not a residual power, but is an exclusive power held by the Commonwealth Parliament. So this might be the case example that you use to discuss, as it clearly indicates an extension of Commonwealth Parliament powers and reduction in state residual powers. And remembering the study design requires you to give an example referring to both state and Commonwealth level powers. Now, I'll skip through this one. It's on the slides more so if you want to have a read. So you're not required to know about the external affairs power under the study design or anything like that. But this is a really interesting case, and it does refer to both state and Commonwealth powers. But if you would like to use this one to fulfill that dot point of the study design, then you will have to have an understanding unavoidably of external affairs powers a little bit. It just refers to treaties, okay, and international agreements. So we've already talked about treaties, so it's still not tricky. So have a read if you're interested. I've got quite a bit of information about it. Okay, so now we'll move on to part 2, which is referring to the courts in lawmaking, the Victorian courts and the High Court in lawmaking. Let's jump right into the content, have a look at the study design. I don't think we should spend time like just reading all the dot points like we did the first time around, but you can see this is all about the courts, their ability to interpret statutes and acts, the doctrine of precedent, which you should remember from year 11, but you will need to be very confident and adept at discussing doctrine of precedent in detail this year, and factors affecting the ability of the courts to make law, as well as features of the relationship between courts and parliament. And again, your key skills dot points with the types of questions you need to be able to answer. So, what is the role of the courts? The main role is, of course, to hear cases and resolve disputes. We just learned about something additional in Unit 4, Area Study 1, which includes resolving disputes between Parliament, constitutional interpretation, and new roles that you haven't looked at before. Now, courts also have a role in making their own laws. Judges sometimes make law when deciding cases that have been brought before them, which is known as common law. Judge-made law is referred to as common law. Law that is created in the course of creating disputes. There are requirements for common law to be made, which you must know. This will only occur if the court resolves a dispute where there is no existing law. So Parliament has not made an act covering that specific circumstance and what should happen and what decisions should be handed down. In that situation, judges will make the decision, therefore creating common law. Additionally, it may occur when the court interprets statutes to apply to the case before the court. So statutory interpretation, we said, refers to interpretation of acts in order to resolve disputes. And this will occur if there are gaps in that act, or it isn't exactly clear, or that specific circumstance hasn't been clearly defined as to what should happen. Then they will actually take that act or statute and read it and try to decide on what Parliament had in mind when they created that act, and based on the wording in that act, what they would have wanted to be done and what they would have wanted to be the decision. Of course, judges could be wrong about this either way because there's a gap or a lack of clarity or a mistake. Common law will be developed. So be really confident in discussing these 2 points, the requirements that must be present in order for common law to be made through judicial disputes. So when a decision is made in the above circumstances, common law will be developed further, and a new legal principle will be established known as precedent. So precedent refers to those decisions that further develop common law developed in court cases, but precedent is actually legally binding on the courts. So precedent sets clear law that judges in future cases with similar circumstances will have to follow. Meaning, if a similar dispute comes up, any lower case, any court that's lower within that same court hierarchy, so for example, the Victorian court hierarchy, they have to abide by the precedent that's already been established. So that common law principle will apply to all future court cases with similar circumstances, and only a court that is on the same level within the court hierarchy or a higher level within that court hierarchy may change that precedent if the judge or justice thinks it's inadequate or it's wrong. But it must be a higher court for precedent to be changed. So this is referring to the doctrine of precedent, the complex process that you need to be able to be confident in and be able to describe and discuss. So the doctrine of precedent refers to this operation of precedent and how it affects those future cases, like I've been talking about. The purpose is because it allows for consistency and clarity in court decisions and how cases have to be decided based upon how previous cases with similar facts were decided by previous judges. That's going to apply to all future cases with similar circumstances, as we said. So when a dispute comes before a court, the first thing that the court has to do or the judge has to do is look to see if there were any similar previous cases that dealt with similar facts. And if there is, they have to apply and follow the same precedent or the same decision that was established in these. The only exception to this, as we said, is if the initial precedent, for instance, it was established in the county court, that means all lower levels of courts must follow the same precedent. So, for instance, the magistrate's court, which is lower than the county court, but courts that are on the same level of the court hierarchy or higher on the court hierarchy, such as the county court being on the same level, the Supreme Court and the High Court, they can change the precedent because they're actually higher. This also means that, if the initial precedent or common law was first established in the High Court, for example, which is the very, very, very highest court, only the High Court justices can change the precedent because every other court must follow it without question, hand down the same decision because they are lower within the court hierarchy. So yes, this is complicated. You won't get this straight away unless you studied hard in year 11 and you remember this. So listen to the explanations again and do some more research. Key terms when you're discussing precedent and common law that you should know include ratio decidendi, obiter dictum, and stare decisis. So ratio decidendi refers to the reason for the decision. This is part of the part of precedent or common law principle that is legally binding on all those lower courts in the court hierarchy. And it refers to specifically the reasons why the judge made the decision that they did. So exactly based on what circumstances and things that the accused or the defendant did was that decision handed down. So in any future case, if any of those circumstances are matching up, that means we must follow this precedent. If any of those reasons for the decision are present in another case, we must just follow that same apply the same decision or verdict or sanction, to that case as was made when the initial precedent was established. These are the reasons for the decision, and that's legally binding. Now, obiter dictum is not legally binding parts of the precedent. It is not legally binding. The obiter dictum literally in Latin means by the way. Okay, so these just refer to judges' comments. So this might be comments about Parliament's law as well, about statutory law, talking about how an act is inadequate or unfair or needs to be changed or out of date or needs to be updated. And these may actually influence Parliament to update or change their acts in response to the judge's comments. This is why obiter dictum comments are really valuable, because they have the power to potentially influence Parliament. But they're not legally binding, they're just comments handed down together with a case. They're not part of the decision, like ratio decidendi, and they do not form a part of precedent or common law that future judges in similar cases will have to follow, as they're just comments. Now, stare decisis means stand by what has been decided, and this just refers to the entire principle of the doctrine of precedent and the process you need to be able to explain. So you're expected to use those terms when answering questions, so learn them, be confident in them. Okay, the next thing you need to know are the reasons for statutory interpretation. So essentially the reasons why we may actually need to interpret statutes. And interpret acts. So I already mentioned some of them, like if there's a mistake, if an act is not clear, if there's a gap, if there's a contradiction. All of these reasons might be valid reasons for a judge to have to actually take the act and develop new common law and a new precedent by reading and trying to interpret what Parliament's intentions were when they crafted it. So one of those reasons is problems that occur during drafting, and the other is problems that occur during application. So problems that occur during drafting are probably the most common, because think about, an act is a very, very long piece of law. I don't know if you've ever read an act, but it can be hundreds of pages long. It goes through a rigorous process when it's being drafted, and it's very common for there to be a mistake or inadequacy or circumstances that Parliament did not think about. So be able to give some examples. Some examples are literal mistakes. If future circumstances were not taken into account, so just like the Brislin case we looked at, where it was the other-like services, they couldn't predict what future technological developments may look like. It might not be clearly expressed what should happen if a law is breached or under certain circumstances. There might be inconsistent use of wording, and it may not cover new technology. Just some examples. Okay, now problems that occur during application include things like if the act or statute is way too broad and doesn't clearly define everything that might happen, if it is already slightly out of date, and that's why it's difficult to apply it, if words are ambiguous, meaning unclear, or have contradictory meanings, if the act has gaps, which the court needs to fill, so circumstances that were not considered when drafting the act, and even the idea that the meaning of the words can change over time. So language, as language progresses, if an act has been around for a long time, that same word may mean something else or something slightly different. Now, you also need to know the effects of statutory interpretation. You do need to read up a little bit more on these, but I'll just explain them as we go. So the effects include developing a new precedent. So obviously, we talked about this, that if an act is lacking or something is missing or there is no existing act for a judge to follow, of course, in that instance, that fulfills that criteria for creating common law. So whatever that decision that the judge makes, it's going to become a new precedent under the doctrine of precedent that will have to be followed in future cases. So precedent or new common law being created is one of the potential effects of statutory interpretation. Another one is that the words or phrases in acts are given meaning. So obviously the meaning or intention behind an act or statutory law is clarified because the judges have interpreted it and what Parliament meant by it. Also, the scope of legislation can be restricted or expanded. So whether the judge takes on a more of an activist approach, wanting to expand the law, or a more restrictive approach, wanting to narrow it down, depending on how they actually conduct their statutory interpretation, they might restrict or expand the scope of that legislation. So similarly, if we look back to the Brislin case, it's a really good example for what we're talking about. Here we can clearly see that the scope of this legislation was expanded because they took other like services to mean a very broad term referring to any technology that comes along in the future. Okay? But similarly, the scope of the legislation could have been narrowed if the High Court had interpreted that other like services may only refer to specifically services that are postal, telegraphic, or telephonic that are in some way very, very, very similar to the services already existing when this legislation was drafted. In that case, Brislin would have won this case, okay, and would have not been charged with an offense. So that's exactly what that's referring to. So those three are usually very, very easy for students to grasp and remember, as well as the reasons for statutory interpretation. So these are very easy marks on the exam and any SAC questions and very easy to explain. Okay, now the next thing that we need to know is the factors that affect courts in lawmaking. So these include the doctrine of precedent, obviously being restricted, having to follow it, having to abide by it if it's already existing, which we already talked about. Different approaches to actually being a judge, so either the conservatist approach or the activist approach. Cost and requirement for standing. So look at each one and we'll look at the strengths and weaknesses. So obviously the strengths of the doctrine of precedent include that actual purpose of the doctrine of precedent to ensure consistency and fairness, because it ensures that all cases that have similar circumstances must be treated in the same way. It would not be fair if a person did exactly the same thing as another person, say with regards to a criminal offense, and then the consequences of that action are completely different. So one person gets let off because there's no law for that circumstance, and the judge conducted statutory interpretation and decided that that person shouldn't be punished, and that's what Parliament intended. But another person gets punished and goes to prison because the act was interpreted differently by another judge. So that's why we have the doctrine of precedent, and all future cases with similar circumstances must be treated in the same way. The same type of decision must be handed down, and we ensure consistency in that manner. Additionally, by looking at past cases, litigants can judge how their case is likely to be decided. So you could be a plaintiff, for instance, considering if it is worth initiating a certain civil claim against a person or a business or something like that. And you can actually obviously access those past cases and see what precedent was and if there is an existing precedent that needs to be followed. And then that your case has similar circumstances, so you're likely to get that same beneficial decision, and you'll get those damages from the defendant, and you'll probably be successful. So it actually helps to see if pursuing a case is worthwhile and initiating, for instance, a civil claim is worthwhile. Also, courts can develop law where Parliament has not yet created statutes. So all those gaps in statutory law and in acts can be filled in by courts because they're doing statutory interpretation and because they're developing common law and new precedents and new principles. Now, some of the weaknesses, so it can be inefficient because in order to change the law and keep it updated, the litigants must bring a case before the court. So there is the requirement for standing. Only someone that is directly affected by a law can initiate a case with regards to that law. Okay. Additional weaknesses are the requirements for costs and time, obviously. So not everyone has the time or the money to initiate and pursue cases through the courts. Depending on cases coming before the court, expensive and time consuming. So exactly what we talked about. Now, another one, it's obviously really difficult to know when a judge may decide to distinguish a case. Now, distinguishing precedent refers to the fact where a judge comes in and says, I don't need to follow this precedent, this common law, because actually the circumstances of these cases, my case, and the one in which the initial precedent was established, the circumstances are different. So in that case, if they do that and if they distinguish between those circumstances, the precedent doesn't apply to them and they don't have to follow it and they can make their own decision, even if they're a lower court than the court in which the initial precedent was established. So, it depends on the type of judge if they make an effort to distinguish and make their own decision, because the judge could be a conservative judge, and if there is just a clear decision for them to follow, even if the circumstances are slightly different, they may just choose to follow that precedent and decide those cases are similar enough. I'll just follow that decision. Now, judicial conservatism and activism. So these refer to different approaches being a judge. Conservatism relates to the idea that courts and judges should demonstrate caution when making decisions and rulings that could lead to significant law changes. So conservative judges view lawmaking as strictly the role of parliament, and they prefer to avoid creating any new precedents or making any changes to common law. So they will be really cautious and really conservative. They try to keep the law stable and leave changes to lawmaking to parliament. Um, but this is obviously the positive thing, maintaining stability, ensuring parliament has the most power when it comes to making law. That's all completely fair. However, that means that there are some negatives with conservatism as well. So the weaknesses are that this restricts the ability of courts to consider social or political factors that can be very, very relevant when deciding the outcome of a case or a civil claim. It also means that these types of judges will very rarely try to distinguish precedent in order to be able to make a different ruling, and they'll just follow whatever precedent already exists. And they will not be proactive in changing the law or helping common law to develop further. Now, judicial activism is just the opposite. So this relates to the idea that courts and judges should be considering a variety of factors when they interpret acts and decide in cases, that they should be helping common law and new precedents to develop, and whenever there is an opportunity for statutory interpretation, that they should take it and make the most of it. So positives are that this allows judges to recognize the rights of people as well as even the community's views, and consider that when passing judgments in order to make them more fair. And then the weaknesses, because they can really make drastic changes to common law and really drastic statutory interpretations, this may lead to more appeals, with people being unsatisfied with activist judges' court decisions. And it could lead to radical changes as well that don't sit well with the community. Radical changes to common law. Obviously, though, we don't want uh, court rulings and everything to be unfair and narrow and restricted. So judicial activism is the beneficial approach. And we said cost and standing are the two factors remaining that we need to discuss. So the cost of bringing a case to court obviously is very, very pricey, especially the higher in the court system we're looking at. So especially if someone wants to initiate a case to the high court, that is extremely expensive, extremely pricey, such as, if their express rights have been breached by a law, Many people, even if they have standing, will not have the time or the money to be able to pursue that. We know also that many people don't qualify for legal aid. It's only available to people in the lowest income brackets, and it's much less um, available for anyone in the civil justice system in comparison to criminal. So that's very problematic, and that can deter individuals as well. But this is really a big flaw because courts can only make law on cases that come before them. Courts cannot develop precedent or complete statutory interpretation or interpretation of the Constitution if that case isn't coming to them in the first place as part of the dispute. However, there are still some strengths when it comes to the cost of bringing a case to court. One is that this can discourage frivolous claims. Now, if going to the courts was free or very, very cheap, imagine all the ridiculous things that people would go to court for and initiate cases for. We have backlogs of cases as it stands, very, very bad backlogs. So there is a reason that going to court is so expensive, and it's to help aid that and make sure that only people that really do need to go to court are going to court. So this helps to discourage any ridiculous claims. It also helps to encourage parties to use alternative methods or other institutions. So, using things like mediation, arbitration, and conciliation, accessing a tribunal in their state or area, or a another service that can help to decide that, like Consumer Affairs Victoria. So this helps to again reduce the burden on the court system by using alternative methods. Now, the weaknesses, litigants, so people who want to pursue their case or rights in court, may not be able to afford costs, even though they have standing and they're affected directly by a matter and their rights have been actually breached. They still might not be able to afford it. It can also deter parties from pursuing the appeals process because appeals are even more expensive, and we know that people do not have an automatic right to appeal. It might get rejected unless they have like a really, really sufficient grounds for an appeal. But you still have to pay for just trying to lodge that application. And then, of course, the requirement for standing, and we said that this is the requirement that the litigant has to be directly affected by the issues involved in the case in order for the court to be able to hear the case. So I can't go to court because someone did something to my friend or a law breached the rights of my friend. It has to be directly relating to me and affecting me. So strengths include that only cases can be brought to court by people who are generally affected by an issue, that their rights have definitely breached in some kind of way. And it also encourages people not directly affected by an issue to seek other avenues of redress rather than in creating a burden upon the courts. So, such as starting petitions or demonstrations or talking about it on social media, basically just trying to get the government's attention or, you know, raise awareness so that someone with standing does go to court. But weaknesses, people who have a general interest in a case or activists or interest groups have no right to pursue a legal challenge on behalf of the greater good. And potential improvements to the law that could have been made by listening to those with only intellectual interest in the case are lost. I would really add here that laws that are unconstitutional or unlawful continue to operate unless that person with standing eventually comes along. So that's a really big weakness as well, that we might have unconstitutional laws just continuing to operate. Now you need to know about the relationship between courts and parliament. This is our last little bit of content. So these include the supremacy of parliament, courts influencing parliament, statutory interpretation, and codification and abrogation of common law. So the top three should already be familiar based on what we've been discussing. So first of all, the supremacy of parliament. We said that parliament is supreme over the courts. Common law is important, yes, but statutory law ultimately prevails. Just think about statutory interpretation alone. The courts when developing common law are just interpreting acts or statutes to decide what Parliament would have wanted and what they meant in their legislation. So that clearly indicates that Parliament is the supreme lawmaking body, and statutory law is supreme over common law. So Parliament can make or change the law as long as it is within their constitutional power, and this includes overriding any common laws or court-made laws. So if they disagree with new precedents that courts have developed, they can just override them by changing their acts and therefore making those common law precedents of the courts just invalid. This also means that Parliament, so as I said, means that Parliament can pass legislation that either confirms or overrides court decisions, does not agree with them, and abolishes them. They can even pass legislation to change the jurisdiction of the courts and their scope, so their original and appellate jurisdictions. Okay, and the next point is about courts influencing Parliament. So we said they have that non-binding part of precedent, which is the obiter dicta comments, the comments made by the way as part of deciding a case. So these comments can be direct addresses to Parliament. They're the opinions or statements that do not affect the outcome or the judgment of the case, because courts are still restricted. They still have to follow whatever Parliament laid out in that act, even if they don't agree with it. But they could point out to Parliament that there is a mistake somewhere, or that law that they had to follow is not fair. And then Parliament might decide to change it and actually amend or change their act or law. So this is how courts are able to influence Parliament. Okay, the next point is about statutory interpretation. So the courts are being responsible, for applying the law, and therefore applying statutes is important and trying to interpret Parliament-made law. And we said the reasons for statutory interpretation, the effects. So that's exactly what you'd be discussing under this point. This enables judges to clarify words and phrases within legislation, make them more clear, and to broaden or narrow the scope of legislation, and how it operates, and develop common law and precedent further. And now lastly, codification and abrogation of common law. So this refers more to what Parliament can do. We said they're the superior body, so they can either codify or abrogate common law. So the codification of common law, codifying it means confirming a legal precedent set by a court or that common law. This is where they pass legislation that confirms that precedent and shows that they agree with it, and then they make it part of statutory law as well, Parliament law. And this is how they demonstrate support for those legal principles. Now, abrogation is the opposite. This is where they disagree, and they can pass legislation that overrides or abrogates a precedent set by a court, saying they don't agree with it and they're taking it out. And of course, because courts must follow statutory law when making their judgments, this means they will now have to follow whatever Parliament changed the law to. So whatever precedent that existed, it's going to be gone. It's going to be abrogated. The only exception is for high court decisions based on matters relating to the Constitution. We said the High Court has that power to declare Parliament's laws unconstitutional or ultra vires and immediately declare them invalid. So Parliament cannot override that. That's not within their scope. Everything else, yes, they can abrogate any other common laws. So this usually occurs as a result of Parliament either believing that the courts have interpreted statutes incorrectly and they didn't get what Parliament wanted through their statutes, or if they create a common law that does not reflect the societal views accurately and is not fair. Okay, amazing. That's all of the content for Unit 4 Area Study 1, guys. I hope you enjoyed today's lecture, and I hope you got a lot out of it, and it's really helping you get that head start for Unit 4 and everything. Thank you so much for coming along, and I hope you are enjoying your term break, and best of luck for the rest of the year ahead. Thank you, everyone.